We live in a world that runs on code and data, right? But how does something as ancient as the law even begin to keep up with that? Today, we're going to explore exactly that, the operation of law in our modern information society.
This explainer is based on the works of Professor Vahar Kiskinov. His work gives us a really fascinating framework for understanding how law actually functions in our increasingly digital world.
So, here's our plan. We'll start by looking at how our understanding of law has evolved. Then, we'll dive into the modern idea of law as a complete system. From there, we'll see how that system works in virtual spaces, uncover a new model for how digital law operates, and finish up with a practical blueprint for the future. So, let's get started.
All right, so to really understand where we're headed, we have to first understand how we got here. The whole idea of how law works has gone through a massive transformation over the centuries, changing from just a simple list of do's and don'ts into the complex, interconnected systems we have today.
You know, if you trace the history, the progression is actually pretty clear. Way back in antiquity, law was just seen as a set of direct commands. Fast forward to the 19th century, and the view shifted to law being a kind of technical mechanism to achieve social goals. Then, the 20th century gave us the idea of a dynamic structure of norms. And that brings us to the modern view, seeing law as a complete, functioning system where all the parts interact.
This quote from the Roman jurist Modestin perfectly captures that classical view. It's simple, it's direct, and it's mostly reactive. It's a really important starting point, for sure. But, as you can imagine, as our societies got way more complex, it became obvious that this simple definition just didn't cover what law really does anymore.
And this is where we hit the biggest change in modern legal thinking. The move away from seeing law as just a collection of rules and toward understanding it as a deeply interconnected, dynamic system.
I mean, the contrast between these two ways of thinking is night and day. The classical view is static, kind of like a dusty library of legal books just sitting on a shelf. But the systemic view? That's much more like your computer's operating system, where all these different programs and processes are constantly interacting with each other to produce an overall effect on society.
So what are the actual parts of this system? Well, you've got the norms. Those are basically the rules. You have the subjects. That's you and me, the actors. You've got legal acts, like signing a contract. Legal relations, which are the connections that form between us. Legal facts, the events that actually trigger the rules. And finally, you have legal concepts, the tools we use for thinking, like the idea of property or contract. But the big takeaway here is that none of these things exist in a vacuum. They all work together.
Okay, so if law is this big, complex system, how does it, do anything? What are the actual mechanisms that make it run and influence the world around us?
The theory breaks this down into two really important types of mechanisms. First, you have what are called constructive mechanisms. The best way to think of these is as the architects of our legal world. They build the entire framework that law operates in. They create the concepts, the rules, and the official registers. Then you have the regulatory mechanisms. These are all the things that happen within that framework, like when you sign a contract or apply for a permit.
And this distinction, this idea of building the world versus regulating the actions within it, becomes absolutely essential when we step out of the physical world and into the virtual environment. This is a genuinely new frontier for our legal systems.
And this really gets us to the heart of the challenge, doesn't it? How do you take a legal system that was built around tangible things and physical presence and make it work effectively in a world that is made entirely of information and code?
The thing is, the virtual environment plays by a completely different set of rules. Our identity is confirmed by electronic means. Our will is expressed with a click, not a physical signature. The technology itself can execute rules automatically, without any human intervention. And the facts of a case are nothing more than bits of electronic data. This, as you can probably guess, changes everything. So, to tackle this challenge, Professor Kiskinov proposes a new legal model. And it's a big shift in thinking. It asks us to stop seeing law as just static text on a page, and start seeing it as a dynamic information system that actively transforms legal will into executable code. This model lays out a new life cycle for how law works online. It starts with construction, which is translating the legal text into a logical software model. Then comes realization, where an electronic agent, basically a piece of software, executes that model automatically. Third is control, which are the essential safeguards to protect our rights and fix errors. And finally, there's evolution, where the data from the system's operation is fed back to improve the law itself. It creates this incredible dynamic feedback loop.
Now, this brings up a really important question. If a computer makes a legal decision, who's responsible? The model makes a crucial distinction here. The technology is just the source of the statement. It's the messenger. The true source of the will is still the human institution that designed and approved the rules that the software is following. The code doesn't have a will of its own. It's just an instrument.
This new model also reveals a totally new kind of legal error, the code-law mismatch. This is what happens when the software's code doesn't accurately reflect the legal rule it's supposed to be enforcing. It's essentially a bug in the translation from law to logic, and it can create a totally illegal outcome even if the original law itself is perfectly fine.
Okay, so let's pull all of this together. What are the key takeaways from this new model? What does this blueprint for digital law actually mean for how we live and work online?
There are three huge implications here. First, legal will itself is transformed. It's no longer just text, it's expressed through code. Second, law's constructive function becomes more important than ever. Online, law has to first build the reality, the systems for identity, ownership, and so on, before it can even begin to regulate it. And third, this new risk of a code-law mismatch means we have to develop entirely new ways to legally review and challenge automated decisions.
So, the bottom line is this. Trying to govern our digital world with a messy patchwork of old, separate laws just isn't going to work. The model suggests that what we really need is a single, comprehensive legal framework. You could almost think of it as a digital constitution that sets down the fundamental principles for all online legal interactions. That's how we create a stable and predictable foundation.
And so that leaves us with one final and pretty deep question to think about. As more and more of our reality becomes virtual, is it inevitable that our laws must also evolve from being static text into dynamic living code?